It doesn't make any sense. And then that's like a piece of paper that says plaintiff has a judgment against the defendant for 13,816.98 plus his court costs of probably another couple $100. There's two parts of every lawsuit. The first is, do you owe the debt?
I do.
And the second is, can you pay?
I cannot.
So maybe you do a consent judgment just for the amount. Over a credit card, is it, counsel?
Yes, Your Honor.
How much do you think is owed here?
Is that question for me, Your Honor, or the defendant?
Yes, it is. I'm sorry.
Damages sought in the complaints, $13,816.98. And we would seek some court costs if we got to
Right,
that
I
point as
got
well.
it. I don't think I have the complaint. Oh, yes, I did. I'm sorry. Yeah, there it is. Sir, do you owe that amount?
I do.
So let me do this. Why don't you go into a breakout room with Mr. Tetro? My court officer will take you to a computer. You guys can maybe put together an agreement.
Don't believe an agreement can be reached.
Well, if you owe the money, why are you saying you don't think you can reach an agreement?
I don't get funds to do that.
Well, I understand. So part of this is going to be an installment payment order. Are you still working?
I've been retired for 4 years. I'm just living on Social Security, trying to take care of two people. I'm living in the poverty line right now. I'm living below the poverty mark right now. I have no assets. I am a renter. I have no bank accounts.
So it doesn't sound like you're going to be able to collect if all that's true.
I do not have
Here,
any assets.
just listen to me for a second. And I don't know how in the world they're going to collect it if you're not commingling Social Security benefits with other accounts.
I have
Listen to what I'm telling you. As long as that Social Security money's going into a separate account and you're spending it, I don't know how they're going to collect it if you have no other assets. Do you understand what I'm telling you?
Yes.
Okay. So why don't you still go in and talk to Mr. Tetro and see if you guys can resolve this in any form or fashion, okay? Doesn't make any sense for a lawsuit to go on if everybody agrees that you owe $13,816.90.
The amount is correct because of my financial situation.
No, sir, I understand. You're not the first that's having financial problems. I get it. I understand. So why don't you go talk to Mr. Tetro? My court officer is going to take you to a computer. He'll put you online with Mr. Tetro in a breakout room. We'll put you in. You guys can talk, okay?
So, may I make a comment?
Yeah.
I've been assessed by Wayne County last month, my total monthly income, because I requested food assistance last month. So I was assessed by Wayne County. I have a breakdown of my total monthly income.
Nobody thinks you could pay this. You convinced me you can't pay this.
Because of the fact that I don't have any assets,
You
just one used vehicle,
sir,
I
Sir,
want to go with
sir.
judgment of proof.
listen to me. They're not going to just let it go. They're going to want a judgment. And now the question is, can you pay?
So I
Listen, please listen. Please listen. They're not just going to dismiss the case. They're going to want a judge. Now, if you don't have any assets, they can't collect on them. You understand what I'm saying?
Social Security is my only income.
I heard you. Did you hear what I just said to him? He can't collect on that. He knows that. He knows he can't go into your accounts and start garnishing Social Security benefits. Okay? So
Yes.
other than them having a piece of paper that says that they've got a judgment against you, I don't know what more they can get. But I have no authority to dismiss the case. They're going to want a judgment. I'm suggesting that you go talk to him in that room and speak to him. Okay? You understand what I'm saying? You don't understand what I'm saying? I'm asking
Your Honor.
I understand what you're saying about going and talking with him in the room. And after the conclusion of this conversation, where am I at?
You guys are probably going to enter into a consent judgment, which he's going to get anyway, because you just agreed that you owed the debt. Well, listen to me.
I don't understand what that means.
Okay,
Consent judgment.
that's fair. That's fair. If you agree to, they are going to present the court with a judgment that's signed by both of you that indicates that you owe $13,816.98 plus whatever court costs he has. And then that's like a piece of paper that says plaintiff has a judgment against the defendant for $13,816.98 plus his court costs of probably another couple $100. But now the question is, can they collect them? And I don't even think you need an installment payment order because you don't have any funds that they can attach. You're not working, right?
I'm retired.
Right. You can't garnish your wages. You can't garnish bank accounts that consist solely of Social Security benefits. So they're pretty much out of luck. Does that make sense?
Yes.
Okay. I'm just saying, go talk to them, see if you guys can at least agree to submit to a consent judgment. We can put this to bed today. And then, I don't know,
Will you tell me what a consent judgment is?
it's an agreement between the two of you that the plaintiff has a paper judgment that says that Capital One is entitled to collect against you the $13,816.98 plus their court costs. Means nothing more. If you agree to sign it, if not, he's got to jump through hoops, and it doesn't make any sense to me that you'd require him to do that since you've acknowledged you owe the debt. Do you understand what I'm saying?
Yes.
Go talk to him. I'll put the file aside and you come back in, okay? You understand what I'm telling you? Yes?
Yes.
Okay, I'll see you in a few minutes. Mr. Tetro, he's going to take him over there right now. Thank you.
Thank you, Judge. I'm sorry, Yarder. I have a 9:30 just to put you on notice.
That one, Mr. Clark is on that. Defendant's counsel is not checked in and he is in a breakout room with another matter.
Genesis Credit versus Jason Wilson, 2602095.
Yes. Good morning, Your Honor. Margo Team Mammoth, PA 1102 on behalf of plaintiff.
Right. Sir, your name?
Jason Wilson.
All right. You filed a motion to set aside default. You want to
Yes.
proceed with that?
As of now, yes, sir.
Go ahead.
Your Honor, I'm asking the court to set aside the default judgment because I dispute both the validity and the amount of the alleged debt.
Can you keep your voice up for me nice and loud?
Oh, I'm sorry, sir.
That's okay.
On May 27th, I sent Holzman Law a written request for verification. I specifically disputed the debt and requested documentation establishing the amount claimed and the basis for the deficiency. I did not receive that verification.
What did that have to do with you not answering the complaint, though?
When I got a message back from the law firm, they said they would have 30 days to respond. And
But you didn't file an
that
answer
put it
to
on hold.
complaint.
Oh, I'm sorry, sir. What was that?
You did not file an answer to the complaint, though, did you?
No, I didn't. I was waiting for the response. And then I got the response after I got the documentation that I did not appear. And then that's when I filed this judgment.
Counsel, what do you have to say? What is your position on this?
Your Honor, in order to set aside default judgment in Michigan, the defendant has to show good cause and a meritorious defense. The defendant was personally served with the summons and complaint May 16th of 2026. He did request information from our office May 26th, 10 days after he was personally served. So one, that shows he was served and he had actual knowledge. That removes any possibility of good cause for failing to appear. He's presented no meritorious defense to that. If he believes that we were required to provide him any more than was required or that we have provided, at that point, litigation was occurring, and this court had not opened discovery. He's more than welcome to request anything. However, the 30-day validation period he's referring to is under the Fair Debt Collection Practices Act, which begins to run from our validation notice, which was actually sent in December of 2025, to the same address that's on his current motion. He also disputed the notice of intent, and he wanted personal effects out of the piece of property that was sold. The notice of intent to sale and the notice of sale itself were both sent to that same address in February and March, respectively, of 2025. Again, the defendants failed to show both good cause and a meritorious defense, and he needs both in order to set aside the default judgment. I ask that the court deny the defendant's motion.
Sir, do you owe this debt?
Yes,
I'm
sir.
not- You owe the debt?
My meritorious defense is that I dispute the amount based on the alleged deficiency, including whether the plaintiff has properly established the debt.
I'm asking you, do you owe the debt? How much do you owe?
According to the paperwork I received, like around 19,100, I thought.
Asking you how much you think that you owe or owe.
One second, sir. I was looking at like a difference of $8,225.
Do you think that you owe? I'm asking you for a figure right now. How much do you think that you owe?
I was looking at around
There's no
13,000.
rounds. The beauty about math is there's only one right answer and we get it to the penny. I'm sorry, I didn't turn my camera on. My apologies. That's the beauty about math. So I want to know how much you owe according to you. The exact figure.
I don't have that in front of me right now, sir.
I can't find there's a meritorious defense and I can't find that there's good cause and I need both. You were served, according to plaintiff's counsel, on May the 16th. The default judgment was not entered. The copies that I have are a little, it looks like June the 25th. So I'm sorry, I'm going to deny your motion. Defendant's motion to set aside default judgment is denied. My apologies to you, I guess, but that's what I have to do. Good luck to you, sir. If you
Your
want to
Honor.
file a motion for installment payments, I'll be more than happy to entertain that. Okay, you can file
Yes,
a
that's-
motion.
So I have to come in front of go down and file for that motion of,
Why don't
we
you
were-
do this? Mr. Mamet, do you have another case in front of me this morning?
I do not, Judge.
Why don't you go into a breakout room with Mr. Mamet? Explain your financial position to him, where you work, what your income is, what your bills are. And you two can just figure out if you can stipulate to an order regarding installment payments. Something that's not going to,
oh, sorry, sir.
something that's not going to bankrupt you or cause you to not be able to eat, but it's fair to the plaintiff. They've got a judgment for close to $18,000 here.
Yes.
Okay, so
We
we'll put
did
you in
have
a
a
breakout
breakout
room
session before this.
right now.
And I told
Right.
them I would be able to afford $200 a month.
What about that, Mr. Mamet?
Your Honor, as I explained to the defendant, unfortunately, I don't have the authority this morning to accept that. However, now that it's on the record, should the court order it, that would be
Where
the
do
order.
you
of the
work
court.
at? Let me ask you to raise your right hand, Mr. Wilson. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, I do, sir.
Where do you work at?
I work at BASF and Wyandotte.
Okay, so you're making good money. How much did you make in 2025?
Roughly, I think around 120,000.
Wow,
That
good for
was
you.
net pay, net pay.
What do you
Oh,
mean net
I'm
pay?
sorry, gross pay.
Gross, I get it.
Yeah.
All right, unfortunately, we all have to pay taxes. What kind of bills do you have, sir?
I got a house payment of 1745 a month,
Okay,
car payment of 500,
okay.
insurance is 800 a month.
$800 a month for car, what, for car insurance?
I have multiple vehicles on it.
Okay, go ahead.
My DTE payment is 520
Well, that's
for
a lot.
gas.
Where do you live at?
Brownstown,
How big's your house?
like 2,000 or
Yeah,
no,
you're not paying 520 per month for 12 months. I
23.
just got mine was 520, but that was because of the air conditioning, right? So anyway, you
Yeah,
can,
I'm on a
Go
budget
ahead.
plan at 520 a month.
wow, maybe you need to rethink that, or I don't know what you put your thermostat at, but go ahead.
Of course, I have my DirecTV and AT&T 167,305.
What do you mean
And,
167,305?
Oh, I'm sorry. DirecTV is 167 a month. AT&T for cell phones and internet and everything is 305. And then I have a credit card payment of 140 a month.
And you have to get food. Are you married?
Yes, but I'm under the assumption that this is just taken in my income, not my wife's.
Well, I mean, there's truth to that. I'm just asking if you're married. Does your wife work?
Yes, she's a school teacher.
How much do you make? So you guys got to maybe budget your money better. I don't want to sit here and lecture to you about that, but if you're
Oh,
making over $200,000 a
Yeah,
year,
I'm not disagreeing with you with that.
all right. You want to ask him any questions, Mr. Mamet?
No, Your Honor. However, again, if the court would order it this morning, that'll be the court's order. I
That's what
can't
I'm gonna
accept
do.
it. But
I'm going to do that. I'm going to order defendant to pay $200 per month. Can you start on the first of the month?
Yes, sir, I can.
All right, installment payment order. Counsel, I'm going to ask you to send me one. Defendant to pay 200 per month beginning September 1 and the first of every month thereafter until paid in full. This order is subject to review on motion of either party, January the 31st. On or after 131 of 27. Okay?
Yes, sir.
So stay with that, and they cannot garnish your wages. They still could garnish bank accounts, they still could garnish tax return, but they cannot garnish your wages, okay?
Okay.
So make sure you get that to them by the first of the month. Do you need to go into a breakout room and tell them how the payment should be made, Mr. Mamet?
yes, Judge, we can do that.
We'll put you into a breakout room. Thank you, gentlemen. Good luck to both of you. Thanks, Mr. Wilson.
Thank you, sir.
American
Honor-
Express.
Oh.
I'm sorry, did you say something?
Yes, Judge. Sorry. Would the court like plaintiff to submit the order denying the motion and the motion
I
for
would.
installment payments?
I would.
Excellent. Thank you, Judge.
Thank you very much. American Express versus Kenneth Brown, 2602167. Who do I have for American Express here?
Good morning, Your Honor. Cezanne Barta, P65425.
Good morning, Mr. Barta. How are you today? Good?
I'm wonderful. How are you?
Good. Where is Mr. Brown at? Is he out here somewhere? There you are. Mr. Brown, your name? I thought it just, Mr. Brown, you have to start your video and tell me your name, please.
Hi, my name is Ken Brown.
Good morning, Mr. Brown. How are you?
Good, how are you?
Did you two talk and try to resolve this, Mr. Barta?
We did, Your Honor.
Any resolution?
No resolution at this time, Your Honor. We're kind of in the exact same situation as we were in the prior matter, in that today's the day and time set the plaintiff's motion for summary disposition. I don't believe there's a response filed. I don't believe Mr. Brown's disputing. We're just trying to get it resolved. American Express has some strict and tough guidelines in how much time debts have to be paid off. And because of the amount and that time duration, we're looking at $650 a month is the lowest that I can go.
I got it. Thank you. I get your directness here.
Yeah.
Mr. Brown, do you owe this debt? He's filed a motion for summary disposition.
Yes.
So do you want to add anything? Otherwise, I'm just going to find there's no genuine issue as to any material fact. And we're going to put the figures on the record, and then I'm going to entertain the motion for installment payments. So you want to go ahead and do that? So I'll just indicate motion for summary disposition granted. There's no genuine issue as to any material fact. And I'm going to allow you to go ahead and set forth your figures.
Your Honor, there is an order attached to our motion, and the damages are $24,066.82, plus just the court costs of the filing fee, the service fee, and the motion for summary disposition fee, which come out to $227.76 for a total judgment amount of $24,294.58.
Jennifer, do you have that order? I don't see it
I
attached
do,
to
Your
my-
Honor. It's in my pending because it was a separate
That's
document.
fine.
I can send it to your box for signature.
Perfect. So we have 2406682, plus we have 22776, total 29294.52. All right, so I'm going to enter a judgment in that amount, Mr. Brown, okay? Now, I'm going to swear you to an oath, so you don't have to come back. And we're going to have a hearing on installment payments, all right? So I'm going to ask you to raise your right hand, please. Do you solemnly swear or affirm? Let me see your hand, please. Solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes, I do, Your Honor.
All right, sir, could you tell me where you work and how much you make? And then you're going to follow up with what bills you have.
Okay. Do you need me to present that information now?
Yeah,
Okay. The figures I don't have, like off the top of my head, I'd have to get those.
where do you work?
But I am self-employed.
Okay,
I suspect probably the figures right now for like how much I make.
yeah. How much did you make in 25?
25. I think it was 65,000.
Are you sure?
I would need to get that information. I'd have to pull that up.
How much can you afford to pay weekly or bi-weekly or monthly?
Monthly, I can comfortably pay around 600.
All right. Can you live with that, or did you say 650, Mr. Barta? You're muted.
Your Honor, I can live with that.
All right. So here's what I'm going to ask you to do. I don't need to
Fine.
go through anymore unless you want to ask him questions, Mr. Barta.
No, Your Honor, I'm fine with that. I just want to make sure that he's comfortable, that he can make those payments and he's not going to default, because
Right.
if he needs some latitude and leeway, you can order something else.
So I
Okay.
want to be clear, Mr. Brown, I certainly don't want you to, nor does Mr. Barta want you to not be able to eat or go into bankruptcy. So truthfully, I'd rather you err on the lower side than the higher side. You follow me? That's $7,200 after tax money per year. Can you afford that?
Yes, I can, Your Honor.
You're sure?
Yes.
All right. Defendant to pay $600 per month beginning September 1 of 26. This matter is subject to review on motion of either party on or after January 31 of 27. I'm going to ask you to prepare all of this, Mr. Barta. And remember, as long as you make those payments as agreed upon, they cannot garnish wages. They can garnish bank accounts, they can garnish tax returns, but they cannot garnish wages. And
It is
whether
our-
you're the
Your Honor,
employer or not,
it is our office policy not to file bank garnishments on installment payments that are timely.
so you got that? They're not gonna garnish bank accounts either.
Yes.
All right. So just make sure you make those payments as I just ordered, 600 per month, beginning September the 1st and the 1st of every month thereafter. Order subject to review on motion of either party on or after January 31 of 27. So let's say something happens. I don't know. What do you do for a living?
I run a digital marketing agency.
Okay, so I mean, I don't know you never know what's gonna happen with the economy. If your wages go down, you can file that motion on or after January 31, okay?
Okay, thank you.
Mr. Barta, anything else, sir?
No, sir, I have another one at 9:30 with you, so I'll hang around.
Okay, thank
Thank
you.
you.
Thank
All
you.
right, now I have First Choice Homes versus Talera and Myron Mosby. Myron Mosby and Talera Mosby. Are either one of them here or on Zoom? This is 260-2602.
Miss Mosby is on Zoom, Your Honor.
And
Where's
good
Miss-
morning, Judge Jeremy Piper for the plaintiff.
Ma'am, your name?
My name is Talera Mosby.
Where's Mr. Mosby or Myron Mosby at?
He is sick. He's a diabetic. His blood sugar is high, so he did not attend the hearing today. Due to that, he's fatigued and he has to wait for his blood sugar to come down. He took his insulin.
All right, what do you want to do, Mr. Piper? You want me to go ahead with the pretrial?
Yes, Judge, we did have a chance to talk in a Zoom room, and we would just request a regular scheduling order with a trial date and or a final pretrial date, and we're going to try and resolve it.
Good enough. Just let me make some notes here, please.
And Judge, while you make notes, I just would say for the record, the defendant's answer that was filed in this case basically referred to a bankruptcy filing. We were unable to locate a bankruptcy filing other than one from 2023, which was discharged. I did talk to the defendant. She indicated that they will not be filing bankruptcy, and so we don't have to worry about that for this case.
Is that true, ma'am? You are not in bankruptcy now?
No, I'm not. After we sat down with our attorney, we're going to do a different way, of course, and try to resolve the matter outside of filing bankruptcy.
Okay. CD on Myron Mosby, we're just gonna make a note. Appearance line not present due to medical condition, okay? All right, so I'm gonna go ahead. And Mr. Piper, what is your P number, please?
Sorry, Judge, 63008.
All right, I'm gonna give you discovery. Is that what you guys want? Is discovery? You want discovery?
We don't request it, but if that's normal, that's fine.
Ma'am, can I just interject here? I can order discovery if they have something that you think is going to help you. If they have documents that you want, that you think are going to help you. If this is just a question, though, of you owing the debt, well, this is a mobile home, right?
It's a purchase of a mobile home, yes, Judge. That got delinquent.
How are you going to be able to pay, or how delinquent is she, counsel?
As of last Friday, the arrearage is 5,218.
What do you think the value of your home is, ma'am?
Probably 70,000.
All right, so we want to make sure you can pay that. You're going to be able to pay that so you don't lose it? I mean, if that's all you owe is 5,200 and some, what is the total amount of the debt that she still owes? That's the arrearage right now. What's the total amount of the debt that they still owe?
$61,576.
So you don't want to lose. You got $8,500 at roughly in equity. If it's $70,000, you don't want to lose that. Why don't you figure out a way that you can come up with the money? Can you think you can do that?
We've been working on doing that by attempting to pay more than our mortgage amount. It's just been a hardship because of my husband's pending disability case with the state of Michigan. So with that monthly reduction, $3,000 to $4,000 per month is why we fell behind. But we have made good faith payment in making monthly payments to the 765, and then because we can pay like $1,000 per month to try to catch it up in the
Here's what I'm
meantime, and
gonna
then
do.
so
Here's what I'm gonna do. I'm not gonna grant discovery. It sounds like this is pretty cut and dry. What I am going to do is set a trial date out there a ways. We're not gonna have a settlement conference. Jennifer, I'm gonna put 1/2 hour for trial. We're gonna set a witness list. You have to file your witness list by October the 30th. You don't have to file a trial brief. If you choose to file one, you have to file and exchange it not later than 7 days before the trial date. Jennifer, I would like a trial date for the latter part of November, okay?
Okay, Your Honor,
Counselor, you're gonna give them a little bit of time to try to resolve this, right?
Yes, Judge. We haven't had any substantive talks because we were told there was a bankruptcy. So we're happy to engage with the defendants, and I already got their email and their phone number to do so.
Good. Discovery, I'm not gonna allow discovery. If somebody decides they want discovery down the road, they can file a motion for it. We're gonna set the trial date. Do you have any idea when your husband's disability case might get concluded? I trust you have a lawyer, right?
we have an appointment tomorrow, or when is it? It's the 26th at 2 p.m.
Okay, that's in a couple
They need
days, not
additional medical information.
not September, right?
No, not September. This is an appointment to follow up. They needed additional medical
In-
information, so we
In
have
2
to.
days,
so you
right?
gotta
August
go.
26th?
Right.
All right,
Yeah,
give me a
that's
date
right.
at the end of November, Jennifer, or early December, whatever you want.
we have December 1st, Your Honor.
12/1 and at 10:30, is that good?
10:30, yes.
Good.
All right. I wish you well, ma'am. I really do. December 1 at 10:30. Mr. Piper, anything else?
No, Your Honor. Thank you very much. And Miss Mosby will be in contact with you. Thank you.
Do you have another case pending with me, Mr. Mike Piper, here today?
No, Your Honor, I don't.
Have a good day. Good luck
Yeah,
to you, ma'am.
You
Thank
too.
you.
Thank you.
Thank you. Bye.
Did I call Capital One versus Zambeck again? Capital One versus Zambeck and Zambeck, 2505264.
Good morning, Your Honor. Dylan Clark, P88474, here on behalf of plaintiff.
Do I have the lawyer for defendant?
No, Your Honor.
You know, one thing, Judge Smith, that I noticed a difference in? No judges called me when I was a lawyer and said, get on the line, right? Now we got to do this every week, it seems like, multiple times. Give them a call, will you please?
Yes.
Heather, tell them,
Yes, Your
or
Honor.
Jennifer, tell them I need them on the line, please. Capital One versus Chris Betton, 2602604. You can come on up here, sir.
Good morning, Your Honor. Andrew Tetro, P79743 for the plaintiff, Capital One.
Your Honor, I apologize. They have not spoken. I didn't know the defendant was in the courtroom.
That's okay. Sir, your name?
First, back to.
All right. This is
So if I'm still in the breakout room,
no problem. Sir, he has another court date too, so just be patient in there, okay?
Mr. Tetro, can I ask what case that was that you have at 9:30?
yes, it's 26-01151 GC.
Okay, I do have defendant's
You have
attorney
that?
here on that.
Do you have that one?
No.
Oh, here. Edward Mann versus Thompson's Appliance. 2600096. Do I have somebody here from Thompson's Appliance, the agent?
No, Your Honor, they have not checked in. There was alternate service on that.
Is Thompson's is Thompson's Appliance still doing business at 32414 West Jefferson, to your knowledge, in Brownstown, sir?
To my knowledge, yes.
And I believe it's also the residents that go out of business.
And it was returned, Jennifer.
Yes, Your Honor, unclaimed is what I'm seeing.
So 4 trips of attempted service from Dino.
I know, but if they don't live there, that's not very good for me to start issuing warrants for people's arrests. You follow me?
Yes.
I mean, I gotta be fair with them too, even though he hasn't paid. That's terrible. Have you ever tried to do a little bit of research and find out where Adolph Thompson lives now?
The address I found was the same as his business. When I actually saw him at his house,
When?
I was driving, well, I went to,
How long ago?
I don't know, but when he was, when I was initially texting him and calling him to try to get my payments, so I wouldn't have to go through all this. I just kept getting ghosted. So I was able to find the address of his business. And I went to his house there to just talk to him, to see if I could get the money there.
At 32414 West Jefferson?
Yes.
Thing that troubles me is it was well, he might have just not signed for it, right?
Yeah. Your Honor, it does
That's
look like
mine.
the envelope is showing that they left multiple notices. And then after multiple notices, they return it to us unclaimed. So they probably, so someone didn't go pick it up at the post office.
All right, here's what I'm gonna do. He failed to appear for a creditor's exam. I did give you an order for alternate service. I'm gonna have you issue a show cause order. I'm gonna issue the show cause order. They're gonna help you out with the paperwork downtown. We're gonna reschedule this. If he doesn't show then, I'm gonna issue a warrant for his arrest. So Jennifer, reschedule that, give him the order for show cause. It can be served by first-class mail at least 10 days before the scheduled date. Can be served by first-class mail at least 10 days before the scheduled date. I mean, it's only $340 some, right?
Well, yeah, but now because of all.
No, I get it. I'm not suggesting you shouldn't try to collect it. 33125 is what the judgment was for. Now you got extra expenses.
Yeah,
That's how I'm going to handle it, okay?
Okay,
So you go down the hall, they're gonna give you a new date, you're gonna prepare, they'll tell you what to prepare. I'll sign the order for a show cause. If he doesn't show up, I'm gonna issue a warrant for his arrest. Okay?
yes,
All right, sorry you have to go through all this. Best of luck.
thank you.
That
How did the warrant for his arrest do anything?
goes into lien, he gets picked up for something or stopped, they're gonna haul him in,
Okay,
okay?
all right.
Thank you. Doctors Harris, Burkill, Wang Song versus Katie Elizabeth Callahan, 2602165. Good
Thank you, Your
morning,
Honor.
everybody.
Morning, Your Honor. Hal Burke, P69068, attorney for the plaintiff in this case.
Good
Leslie
morning.
Kemp, good morning. Leslie Kemp Smith, P number 35218, appearing on behalf of the defendant, Katie Elizabeth Callahan.
What are we doing on this one?
Your Honor, we had a very cordial and pleasant conversation in your breakout session. Two things. One, I still am putting together the itemized statements that Attorney Smith asked for. There's one missing, and I just asked my assistant to get it today. And in the meantime, I don't want to speak for her, but Ms. Smith made an offer on this case that I'm also going to review with my client.
But I adjourn it another 3 weeks. Is that good?
Perfect.
Yes.
Yes, please.
Okay, let's adjourn this 3 weeks, Jennifer.
Your Honor, let's go with September 22nd at 8:30.
At 8:30. Of course she'd be pleasant, Mr. Burke. She was a judge. We're all pleasant, aren't we?
I agree. No dispute there for sure.
Have a good day, you two. I'll see you on the 22nd.
Thank you.
Thanks.
And
Have a
thank you,
great day.
Mr. Burke.
Thank you.
Jason Serafovich, Citibank versus Jason Serafovich, 2602248.
Good morning, Your Honor. Dylan Clark, PA 8474, here on behalf of plaintiff.
Sir, your name? You have to unmute Mr. Serafovich and then tell me your name, please.
Good morning, Your Honor. Jasmine Serafovic.
All right. Did you two talk in a breakout room?
We did, Your Honor, and we did come to a resolution. Mr. Serafovich is withdrawing his motion and will be entering into a consent judgment.
Okay, you want to give me the terms of that?
Sure. Mr. Serafovich has agreed to make monthly payments of $198 towards a total judgment amount of $11,871.89. That's represented by damages in the amount of $11,584.37, court costs in the amount of $212.52, and a statutory attorney fee in the amount of $75 with no interest accruing. First date of payment will be September 15th, 2026, continuing on or before the 15th day of each month thereafter till the balance is paid in full. And Mr. Serafovich has provided his email address so that I can forward him the consent judgment for his review.
All right, so he's gonna pay $198 per month beginning when?
September 15th, 2026, continuing on the
All
15th.
right, sir, you withdraw your motion to compel arbitration?
I do, Your Honor.
So motion is withdrawn and dismissed, and this will be in the form of a consent judgment that calls for a total to be paid of $11,871.89 at the rate of $198 per month beginning September the 15th. Is that your understanding, Mr. Serafovich?
Yes, Your Honor.
Do you want to read this, or does Mr. Clark simply have your permission to sign your name to this proposed consent judgment? It's right on record here with all those terms.
That's fine, Your Honor.
You consent to him signing your name to that proposed consent judgment with those terms set forth therein?
Yes, Your Honor.
Okay. All right, so you can submit that, counsel?
All right, yeah, I can sign that on behalf of Mr. Serafovich. And then
We're all set unless somebody has something else to bring up here.
I think that does it for this matter, Your Honor.
All right, have a great day, Mr. Clark, Mr. Serafovich. I wish you well.
Thank you, sir. I will.
Thank you, Your Honor. I do actually have a couple of matters in front of you, including that
Okay.
motion for summary where the opposing counsel is not here.
Okay. Has Ann Zambek's attorney shown up?
No, Your Honor, and I called and all I was able to do was leave a message, but I do have an attorney. If you give me Mr. Price.
Yes, I believe we are having a communications issue at my firm.
Yeah, I was just trying to figure out what case you're appearing on.
I'm trying to
the
figure out
case
too.
number.
I believe Attorney Zagararis is here for me, so I can just go.
Oh, okay.
Oh, but let me call this Capital One versus Ann Zembek, 2505264.
Dylan Clark, PA 8474, here on behalf of the plaintiff.
What do you want to do on this?
Your Honor, I'd like to proceed with the motion for summary.
I'm just surprised that I got a lawyer that's just not showing up at all. I mean, all right, give me 1 second. Go ahead. You can proceed with your motion for summary disposition.
Your Honor, this is a plaintiff's motion for summary disposition brought under MCR 2.116 C9 and C10. Attached to plaintiff's motion are account statements, a cardholder agreement, and an affidavit of plaintiff's custodian of business records satisfying all the requirements of MRE 8036. The statements attached to plaintiff's motion were sent to the address where Ms. Zambek was served via personal service. By looking at the statements, you can see that the last payment made on the account was in July of 2024, July 15, 2024. The last purchase on the account was made November 30th of 2024 before the account was finally charged off in February of 2025. The statements show that Ms. Zambek made purchases and then made payments in response to those statements. There's no genuine issue of material fact here. My client's entitled to judgment in the amount of $3,014.16, representing damages in the amount of $2,864.46, and court costs in the amount of $149.70.
Defendant did not file a response either. There is no genuine issue as to any material fact. Plaintiff has granted motion for summary disposition pursuant to MCR 2.116 C9 and 10. Judgments granted in the amount of $3,014.16, consisting of the principal amount of $2,864.46, court costs of $149.70, total $3,014.16. You can submit your judgment.
That followed shortly. Thank you, Your Honor.
Thank you. All right, so I'm moving on from that one. Now I have Paul Ollie versus Bank of America. 2602933. Do they have somebody here?
The Bank of America representative is on Zoom, Your Honor. He is out of state.
Good morning, Your Honor.
Go ahead, your name?
I'm not counsel. I'm a representative of the bank. My name is Dwayne Dumler. I can spell it if you like.
I can see your name. I'm questioning, this is a small claims case. Lawyers can't proceed in small claims. If you want to have the case removed, your name, sir?
Paul Holland.
If you want to have the case removed to the General Civil Division, you'll have to file a notice, a demand for removal.
I'm not an attorney, Your Honor. I'm an assistant vice president of the bank.
I'm sorry. I thought you said you were an attorney. My apologies.
No, you're good. Thank you, Your Honor.
And are you, why would you, okay. Do you guys want to sit in a room and talk about this? Counsel? I mean, Mr. Dumler?
No, Your Honor. I do not believe we have negotiations to. I don't believe we'll be able to settle this.
How long has your mom been deceased, sir?
She's still alive. She's 81. No one said she was deceased.
I know, I'm sorry. I read into that. My apologies to you. Glad she's not. Do you have the physical CD?
I do.
Have you looked into this, Mr. Dumler? I mean, I can't imagine under any scenario, and I haven't sworn anybody in yet. I'm just trying to figure this out. If they purchased a CD with Bank of America and there were other mergers, the bank would have had to assume any liabilities, which would include a CD, right?
Yes, I've looked into it, Your Honor, and we do not have record of it coming from another bank.
Let me see that.
This?
Yeah. Did you send that to Mr. Dumler?
Yes.
That's got to be worth some money now. Unless was the interest paid every year? Was interest on the CD paid every year? Is that the question?
Do you mean, did I collect anything or?
You or your mother?
No, it's never been tried to be redeemed at all. We've never made any withdrawals.
This says, you said here, my mother purchased a CD on November 2180 with Heritage Bank.
If you flip open, there's two different versions in there. That's the original one from Heritage and then the follow from Standard Federal.
Did so he sent all this to you and you tried to track it and you're telling me that looks pretty official to me.
Right. He sent a letter stating from LaSalle Bank, but I mean, there's no other documentation. The letter from Bank of America doesn't have an account number on it. And there's no record that the transfer is actually completed from LaSalle Bank to Bank of America as far as the account goes. And mind you, this was back in 2008.
November 21 of 80, he said. Is that when it was purchased?
That's when it was
The
purchased,
very first
yes.
CD was purchased.
That's what your complaint says here.
Yeah, November of 1980. Yes.
Did you send Mr. Dumler all that paperwork?
Yes. Yes, he has that. He has the letter from Bank of America showing that they're taking over from LaSalle.
But
Not
there's
quite.
there's no record of anything coming from LaSalle. I can't prove that it wasn't cashed before, the transfer was complete.
How do I know it wasn't cash? How do we know your mother didn't cash it?
I have,
You've given me records up to 1900, it looks like, in 96, right? There's nothing since 96 that you have, right?
I have a letter from Bank of America here dated August 25th, 2008, stating as part of this transition, your existing CD accounts will move to the Bank of America system as of Friday, October 17th, 2008. This is a letter from Bank of America
Let me see it.
to me.
And remember, I haven't even put anybody under oath here. I'm still contemplating how I'm going to proceed with this. This looks like a form letter though, right? It doesn't.
Right, Your Honor,
It doesn't reference any account number on yours. It's just telling probably something that was sent to all customers saying your existing CD and or IRA accounts will move to Bank of America system.
But they're denying that they have it, yet they admit that they're sending me a letter. So they are acknowledging that I had an account that they want to, from LaSalle. They're not denying that it exists. They're just denying that they have it. But my question is what happened to it? Because I didn't cash it in and I've checked with the state. It's never been eschewed. So it's
What year was the IRA transferred solely? I mean, the CD transferred solely into your name?
in 2008. I have a letter from 2004, April of that year. That is both to my mom and me, and then you'll see that letter is now just in my name.
What is that letter dated?
April 14th.
What does it say?
It says LaSalle is now part of Bank of America. On May 5th, 2008, we will begin to serve you under Bank of America name.
So you're saying between the time that letter was sent in April and the time this letter was sent to you by Bank of America in August, your mother transferred this solely into your name?
Yeah.
Do I actually have the certificate of deposit in here? No.
That's that thing that I gave you is the original one.
But it's more like a statement, right? Let me see here. I don't want to rip into this up. I'm just curious. You have all this paperwork, but you don't have anything on here after 96. Do you agree with that?
I do, because I wasn't doing anything with it. My mom had it until 2000, physically had it.
Well, how did she, but I'm just trying to think. I can tell you right now, I'm not going to make a decision on this today, as much as I hate to waste everybody's time. It doesn't make any sense that this wasn't transferred to you until 08. And your mother had this paperwork that tells me that it was almost being calculated on the specified dates as to what the interest was accruing. But then there's nothing after 96.
Mhm.
Nothing. She didn't have anything. How old's your mom now?
81.
She's not that old. Is she coherent? No disrespect intended?
She is
Where does she live?
in Trenton.
Is there a reason you can't bring her?
I could. I wasn't asked to, so
No, I understand. She understands everything. She's coherent, right?
Yes.
Okay. I mean, look, I got a mom that's 91. I mean, no disrespect, and she's more than fine. She's probably more coherent than I am sometimes. Okay. Let me think this through, Mr. Dumler. I don't know how you can go about tracking this. I've never had a case like this. I really haven't ever had a case. Do you have somebody in the banking system that you can bring into me that can tell me we've tracked it besides yourself, and here's what we found, and here's what we think had happened, or even you?
I mean, I've done research, right? I mean, when we're talking back to 2008, right? We've gone almost 20 years since that letter was sent. I'm not going to have anyone at the bank that could talk to something that old. Um, I mean, we've searched and no record came over. I mean, the letter could be that LaSalle had an account at some point, right? But again, it didn't come over because it wasn't active. There's no documentation showing any account numbers.
But if they didn't have anything else for them at LaSalle, wouldn't they have taken them off their list? I mean, if this presumably had been transferred years before that, why did your mom or you have anything else at LaSalle?
No.
No other IRAs, no other CDs?
I can speak for myself. I don't know what my mom's finances are, but no.
Would you rather your mother appear by Zoom or in person with you? Can you bring her? I mean, is she physically capable of?
I could bring her.
Bring her. Now, I don't know where I'm gonna go with this. I really don't. I'm gonna have to think about this one. I'm gonna hand you back all your paperwork. And I'm going to ask you to send copies of everything that you have, John, to the court and to Mr. Dumler. Do you have Mr. Dumler's email information?
We've already sent all this to him. He has all of this.
Okay. Is that true, Mr. Dumler?
He did mention one letter from earlier in the year from LaSalle in the Bank of America piece. I do not have that one.
Send that to him. Send whatever send whatever. I mean, there's something wrong though if we buy a CD and banks change companies with it 4 years or 4 times or 3 times or 5 times. And our CD now is gone forever. That just doesn't make any sense to me either. I'm going to adjourn this for 4 weeks, and forgive me, but I'm going to have to think about this one. But I'd like you to give me that paperwork as soon as you can, whatever it is that you have, okay? They could make copies down the hall if you want. Just
Okay.
You'll have to be patient. So let's adjourn this out 4 weeks. We going to the 22nd, Jen?
Yeah, we can do the 22nd, and can we do that at 11?
At 11 a.m. And I'm going to have you keep all that CD and give it to me like 3-4 days before that, okay? They'll give you a copy of that date down the hall, but it's September the 22nd. September 22nd at 11 o'clock in the morning. Okay? Sorry, guys. Hate to make people come back, but I want to make sure I do the right thing here. Thank you both. I'll see you in 4 weeks. Thanks.
Thank you, Honor.
Capital One versus Chris Betton. 262-02604.
Morning again, Your Honor. Andrew Tetro for the plaintiff, Capital One.
Is Chris Betton here?
Yes, there's,
Oh, yeah. Okay, there you are. How you doing? Your name?
Chris Betton.
Did you get a chance to talk to Mr. Tetro?
I did.
What is the resolution, Mr. Tetro?
Your Honor, the parties are going to submit a consent judgment. Mr. Betton has given me permission to sign his name to that document. And I plan to do that after logging off of the hearing this morning, but I can give you in the court record a preview of the numbers if you'd like.
Thank you.
The damages being sought and will be as damages in the judgment is $13,816.98. And we're adding court costs in the amount of $197.10 for a total judgment amount of $14,014.08.
Are there any terms of payment?
No, Your Honor.
So this would be a simple consent judgment where plaintiff would get a judgment against you in the amount of $14,014.08. And he tells me you're giving him permission to sign your name to that proposed consent judgment. Is that true?
Yes,
And you agree to that judgment amount entered in favor of the plaintiff against yourself?
yes, I do.
And if you ever want to file a motion for installment payments, you can, but based on what you've told me, as long as you don't commingle Social Security benefits with other assets, other bank accounts, they're not going to be able to collect on it. Okay?
Yes.
So that's where we are. I'll ask you to submit your judgment. Do you have any questions, Mr. Benton?
No.
Good luck to you, sir. I wish you well. Thank you.
Yes.
Have a good day. Performance Equity versus Tracy Kelly. 2603322. Is Tracy Kelly here?
They are still in a breakout room, Your Honor. I apologize. I had
That's okay. It's nothing to apologize about. Synchrony Bank versus Kausler S. Verk. 22W1220.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff.
Where is Kausler Verk?
Yes, I am here, sir.
Okay, your name, ma'am?
Kosar work.
All right, good morning. Did you two talk about this one, counsel?
We did, Your Honor. No resolution at this time.
Give me a little background, if you would, Mr. Kuipers.
Sure. So this was plaintiff. There was a judgment.
Wait one second.
Your Honor, there's an interpreter for Mr. Verk.
For Ms.
Yeah,
Verk?
Miss Verk, we had an interpreter scheduled for today, yes.
Oh,
Yes.
who is it?
Okay.
Come on up.
Come on up here. Right to the podium there.
How you doing?
Good, good, thank you.
What is your name?
Irfan Sheikh.
Can you spell that name for me, please?
Yes, sir. It's I-R, like Frank, A, and like Nancy. The last name is S-H-E-I-K-H.
I'm sorry. Irfa, I-R-F-A-N,
Yes, sir.
and the last name is spelled,
S-H-E-I-K-H.
all right. And are you, what language do you speak primarily?
Urdu.
All right. And Ms. Verk speaks Urdu, correct?
Yeah, I think
Yes.
so. I was just asked to come from the company to do some translation at the court, like in person.
Say it again.
I was asked to come in person today to do the translation.
Yeah, I understand.
It's
Are you a state certified interpreter?
not state certified, no, you're.
Well, how is it that we contacted you?
Through, University Translators is the.
I see.
Yeah,
But you have some kind of a ability to interpret
yes,
through the state, and that's just what?
I'm sorry.
What is that again? It's not state certified anymore. What do they call it?
I'm not really certified, I just speak the language fluently. I can't read or write it, so that's why I can never get certified. I just grew up.
And you know that you can interpret what she says.
Yes, sir.
And repeat it back to us.
Yes, sir.
Raise your right hand. You solemnly swear or affirm that you will make a true and accurate translation between the court and the parties here.
And
Okay.
Right.
All right, you can put your hand down, ma'am. Tell her to repeat her name to me.
आप अपनी नाम दोबारा बता दें जज साहब को.
सॉरी, क्या कह रहे हैं?
आप अपनी नाम बता दें.
हम नाम कौसर और विर्क, लास्ट नेम.
Most last name is Bird.
All right. Mr. Kite, slowly give us a recitation as to the background in this, please.
वो जज साहब ने वो पूछा था तो आपको वकील को ऐसा से समझा दें जो क्या बात हुई थी आपके साथ.
एड्रेस पूछे.
नहीं नहीं वो
जी
जो
जी
वकील साहब से वो जज साहब ने उसको बोल रहा है तो वो बता दे तो आप लोगों ने क्या बात की है अभी
अच्छा वो बात ये कि जो फंड्स होल्ड किए हैं उनके साथ
I'm sorry. I'm just translating what you're saying and she's repeating. But I'm just translating what you're saying too.
What
जस्ट
did
बात
she
ये
say?
She's
Wait.
trying to give her side of the story.
No, not yet.
Right. अभी कुछ ना बताए मैं सिर्फ आपको बता रहे हैं तो जज साहब क्या बोल रहे हैं
अच्छा
Wait.
ठीक है
Tell her to wait for the lawyer to tell me his version, and he is going to do so slowly, one sentence at a time.
आप इंतजार करें जैसे आपको वकील को पहले बात कर दे दो फिर वो उसके बाद में आपने कोई जवाब देना फिर वो आपसे पूछेंगे फिर जवाब दे
ठीक है
Okay.
So there was a judgment entered on June 16th, 2023 for $8,143.46.
ये जून 13 तारीख 2023 में आपकी जजमेंट हुई थी आपके खिलाफ में $8,000 what was the amount sir?
$8,143.46.
$8,142 और 46 सेंट आपके खिलाफ ये था जजमेंट
ठीक है
Okay.
To date, nothing's been paid, and plaintiff filed a bank garnishment on June 9th, 2026.
तो अभी आज तक कोई पैसा नहीं जमा हुई है इस कर्जा से और आपने बैंक के साथ अपनी फाइल की है what was the date again I'm sorry
June 9th, 26.
जून 9 तारीख 2026
ठीक है
yes
Disclosure on June 30th stating that $4,321.93 was being withheld from 3 separate bank accounts.
वो ये कह रहे थे आप 3 बैंक अकाउंट आपसे वो पैसे रोक रहे थे आपकी 4,300 4,300 and
4,321.93.
4,381 सेंट की आपके बैंक अकाउंट से 3 बैंक अकाउंट से आपने रोक रहे थे
The disclosure was, hang on. The disclosure was filed by PNC, correct?
वो जो बैंक का नाम जो था PNC उसने फाइल की थी ये बात सही है
ठीक है
Yes, and it was for 4 accounts, not 3. My mistake.
तो गलती थी वो कह रहा था 4 अकाउंट थे 3 नहीं थे
ठीक है
Okay.
Go ahead.
Defendant then filed an objection to the garnishment, claiming that she is just listed as a co-signer on the accounts, but the funds aren't hers.
तो आपने भी वो फाइल की थी आपके वकील से जैसे जो ये जिम्मेदारी जो है ना आपने सिर्फ को साइन की थी तो ये जो जिम्मेदारी जो पैसे है आपकी जिम्मेदारी तो नहीं है ये आपका पैसे नहीं है सिर्फ आपने को साइन की थी
ठीक है
yes
However, as explained in a breakout room under Michigan law, if you're listed as a co-signer on the account, they're still applicable to be garnished from a bank garnishment, and therefore plaintiff would request the objection be denied.
तो ये बता रहा था आप जो आपने बात की थी ब्रेकआउट रूम से जो वकील से बात की है जो इवन जो आपके ये जो पैसे आपके नाम पे नहीं था आपने को साइन की है तो मिशिगन कानूनी तौर पे आप फिर भी कदर जिम्मेदार है इस अकाउंट की और आपने पैसे जो निकालते हैं आपकी तनख्वाह से वो उसका पूरा हक है लेने के लिए
मेरा ऑब्जेक्शन है इस बात पे
she's objecting to this
Whose names are these accounts in, Mr. Kuipers?
वो किस नाम पे है ये अकाउंट जो है किस नाम पे है
अकाउंट्स मेरे 3 बच्चों के नाम पे हैं एक अहमद है एक जरनाब और दाऊद तो उनसे बात
they're under the three children of hers one is named Ahmed one is named तीसरे का नाम क्या था
एक जरनाब सेकंड दाऊद एंड थर्ड अहमद and one more question as Michigan legislation section 487
slow down इसका बात करें
Ahmed, how do you spell Ahmed? Is it AHMED?
बेटे का नाम आमिर जो AHMED का स्पेलिंग है
yes MED
How about the second child?
दूसरा बच्चे का नाम स्पेल कर रहे प्लीज
DAWOOD
DAWOOD दाऊद
deed.
Okay.
Yes,
Third.
Dawood.
And the तीसरा
Zarnab, ZARNAB.
NAB Zarnab.
And what about the fourth account?
And the चौथा account किसका है?
फोर्थ अकाउंट इसी बच्चों के 2 अकाउंट थे, तो उनमें से फोर्थ अकाउंट इनका सेविंग अकाउंट था। नाम 3 ही है, लेकिन एक बच्चे के 2 अकाउंट थे, एक सेविंग और एक दूसरा।
Has 2 accounts and it's a savings account on the fourth one.
Say that again.
Oh, the fourth account is that one of the children has 2 accounts. Yeah.
Which child has 2 accounts?
Well, बच्चे का नाम कौन सा है जैसे वो उसको 2
आपका 2
account
अकाउंट था कि नहीं? आई थिंक आपका 2 अकाउंट थे आपके? 3 अकाउंट थे, तीनों में से निकाल लें।
2 accounts से निकाले।
अच्छा, अहमद, AHMAD.
Ahmed is the name of this fund.
Okay, so Ahmed has 2 accounts, Dawood has 1, Zarnab has 1.
तो अहमद का 2 अकाउंट है, ज़ारनब के 1 अकाउंट है और दाऊद का 1 अकाउंट है। सही है?
ठीक है।
मतलब ये सच बात है?
हाँ जी, ठीक है, सच है।
How old is Ahmed?
आमिर की उम्र कितना है?
अहमद की उम्र अब 20 इयर्स है, लेकिन जब को साइन किए थे तब ही वाज माइनर।
He is 20 years old now, but at the time when she co-signed, he was a minor.
How about Dawood?
दाऊद की उम्र कितना है?
दाऊद अब 23 है, बट उसका भी सेम है सिचुएशन। जब मैंने उसके साथ को साइन किए थे तो वो माइनर था बैंक रूल्स
He
के
is
तहत।
23 now, but it's the same situation as the other child that when she signed that he was a minor.
Zarnab.
ज़ारनब की उम्र कितना है?
जरनाब की उम्र कितने साल हो गए उसके? 98 पैदाइश है ना? 28, but I co-signed with her in.
Just answer my question.
बस वो जज साहब की
Was Zarnab 20? Is Zarnab 28 now?
हाँ जी, ठीक
ज़ारनब
है।
की अभी उम्र 28 साल की है?
ठीक है, हाँ जी।
Yes.
Now, you started to cite some statute. Tell me what statute you're citing.
अभी आप जो एक स्टैचू आपको बता रहे थे, जज साहब पूछ रहे हैं, तो वो दोबारा बता दें क्या बता रहे थे अभी आप?
अभी मैं ये कह रही थी कि अहमद स्टूडेंट है, उसके फंड्स लीगली प्रोटेक्टेड है फ्रॉम गार्निशमेंट एंड ही हैज नथिंग टू डू विद दिस डेब्ट एंड जजमेंट। और सेकंड ये कि मिशिगन का जो सेक्शन के तहत
एक सेकंड जज को समझा देना ऐसा ऐसा। I'm telling you, let me explain to you. So what she's saying, she's saying that ended the judgment on him because he's a student and then garnishing. But
What she started to state a statute before, I thought
एक
she said.
statute आपको
Yes.
बता रही थी मिशिगन के बारे में, वो बता रहे हैं।
Yes, Michigan legislation का section 487.718 के थ्रू जो है ना only my part can be garnished as I have no ownership of these assets.
Ma'am, you have to slow down. There's a language barrier here, and I need to understand what you're saying.
ऐसे ऐसे बात करते हैं, ऊंची से बात
wants to talk.
बात कर ले। जज साहब आपको सुनने की कोशिश करता है सुनने के लिए।
ठीक है। Michigan legislation section 487.718 इसके अकॉर्डिंग सिर्फ मेरा पार्ट अकाउंट में अगर होगा तो वही गार्निश कर सकते हैं, और जबकि मेरा इन अकाउंट्स में कोई पार्ट नहीं है और मेरी कोई इनके साथ कंट्रीब्यूशन नहीं है इस अकाउंट्स में, इसलिए।
Ma'am,
एक सेकंड,
just answer my questions.
सिर्फ जज
Just
साहब
answer my question. I asked you just what statute and you're going on. Just answer my question, please.
सिर्फ उसकी जो स्टैट्यूट को पूछ रहा था, बाकी जो चीजें को जरूरत नहीं है, बस इस जो सवाल जो पूछ रहे हैं वो बस जवाब दे दे।
Jennifer.
ठीक है, क्या सवाल है?
Did she say 487.718?
दोबारा नंबर बता दे।
नंबर बता देती हूँ, 487.718।
Jennifer, have somebody print that statute out. I don't know which one she's referring to.
Yeah, I just looked it up. I'm happy to read it.
Thank you. Go ahead. Now, wait a minute. Nice and slow. Nice and slow. Ma'am, do not say anything until he's done.
अभी कुछ बात नहीं करनी, जब ये अभी जो वकील जो है ना वो पढ़ेगा स्टैट्यूट, लेकिन कुछ बोलना नहीं है जब ये पूरा नहीं पढ़ता है।
ठीक है।
It's titled Deposits Subject to Rights of Creditors, Laws Applicable to Transfers and Fraud of Creditors, Claims Against Insolvent Estate of Deceased Owner of Statutory Joint Account. And I can read the whole statute if it's pretty short, but.
Okay, but wait. Slow. He's got to translate this. So slow. I know. I deal with interpreters all the time and I have to remind myself. You probably don't. Slow. Go ahead and start reading.
Okay, वो अभी पढ़ेगा आपके लिए वो पढ़ने को शुरू जज साहब ने बोला था ऐसा तो पढ़ ले जैसे वो समझ हम सबको समझ कर सकते हैं okay
You muted yourself.
क्या कह रहे हैं मुझे
You're
कुछ
still
बोलना
muted.
Sorry about that, Your Honor. It says deposits in a statutory joint account shall be subject to the rights of creditors of the person designated in the statutory joint account contract as owners of the funds to the extent of the ownership, except that the funds shall remain subject to laws applicable to transfers and fraud of creditors. And then there's one more sentence.
Go ahead. What, did you read that to her?
Did I read it to her?
Yeah, you got to tell her what he said.
Yeah, I tell you the truth, I didn't even understand what he said.
Yeah, you got to go slow. You're reading the whole thing. Remember, this guy's got to interpret, and he's not a lawyer. So slow.
Deposits in a statutory joint account shall be subject to the rights of creditors.
Stop.
जो डिपॉजिट होगी जॉइंट अकाउंट में उस जो आप अकाउंट में जॉइंट अकाउंट में डिपॉजिट हो जाती है okay
Shall be
of the persons designated in the statutory joint account contract as owners of the funds.
जो अकाउंट में जो जिम्मेदारी है जो मालिक है ओनर है फंड्स का उसके नाम पे स्टैट्यूटरी उसके नाम पे आ जाता है
To the extent of the ownership, except that the funds shall remain subject to laws.
Hang on. He's not going to remember all that.
Yes, sir.
Jennifer, bring that statute down here, please.
वो उसकी वो जो पूछ रहे थे वो खुद लेके आने के लिए बात करने के लिए
Okay, I want you to start completely over and only go 5 words at a time, counsel.
Understood, Your Honor.
वो कह रहे हो उस ऐसा बात करें 5 लफ्ज में जो हम आपको समझा सकता हूँ
ठीक है
okay
Deposits in a statutory joint account.
What is statutory?
You don't need to know. Just tell her. Deposits in a statutory joint account.
Deposit जो होती है ना उसमें अकाउंट में जैसे वो joint account हो जाता है statutory की
ठीक है
Shall be subject to the rights of.
वो जो हक होता है जो उसकी जिम्मेदारी होती है
Creditors of the persons designated in.
जो उसकी क्रेडिटर जो उसकी जो नाम पे लिखे है ना उस अकाउंट पे उसकी क्रेडिटर की
The statutory joint account contract.
वो जो कॉन्ट्रैक्ट है अकाउंट की joint account की statutory की
As owners of the funds.
जो है इसकी वो जो फंड की जो ओन करने वाले जो है
To the extent of the ownership.
जो उसकी जो अकाउंट के जो जिम्मेदारी है ओनरशिप का अकाउंट के लिए
Except that the funds shall remain.
स्वाई वो जो जमा है पैसे की वो ठहरना चाहिए रिमेन करना चाहिए
Subject to laws applicable.
सब्जेक्ट वो जो कानून के लिए वो जो उसके वो एप्लीकेबल कानून के तौर पे
To transfers and fraud of creditors.
तो ट्रांसफर करने के लिए या फ्रॉड के लिए जो उसकी वो मेन क्रेडिटर का वो जो ओन करने वाले हैं
If in his or her lifetime.
वो आपकी जो जिंदगी में
A deceased person was an owner of a statutory.
वो कोई पहले जो जिम्मेदारी थी वो तो फौत ना हो तो
Joint account, the estate.
जॉइंट अकाउंट में जो हो जो स्टेट के जिम्मेदार हो
In the event of its insolvency.
जो इसकी जो इंसॉल्वेंसी का मतलब ये जो खत्म होने के लिए जो इसके पहले से खत्म होने के लिए से पहले
may recover from the surviving owner
जो जिंदा जो है और जो अकाउंट की जो जॉइंट अकाउंट जो बंदा जो एक फोर्थ हुई है जो जिंदा रहने वाला है उसके लिए
so much of the deposits as were
So much of the deposits as were
जितना वो डिपॉजिट में थे पैसों की जैसे वो थे
owned by the deceased person
जो उसकी जो फोर्थ होने वाले की वो ओनर करते थे इस अकाउंट की
immediately before the deceased person's death.
उसकी जो फोर्थ होने से पहले की उसकी ओनरशिप थी इसके अकाउंट की
To the extent required to satisfy claims.
तो उसकी वो जो फ्लेम्स की थी सैटिस्फाई करने के लिए
Against the estate, and that's the end.
अगेंस्ट की वो आपकी एस्टेट के लिए और वो बस खत्म है
Jennifer, is somebody printing that out and bringing it
Yes,
to
Your Honor, they're walking it down now.
Thank you. Okay, now. Ma'am,
Yes.
आपसे सवाल पूछना चाह रहे
you told me that through the interpreter,
आपने जज साहब आपको बताया था मेरे थ्रू से
the accounts were in existence since your children were minors.
जो अकाउंट जो बारे में बात हो रही है वो उसमें जो अकाउंट में जो आपके बच्चे माइनर थे उस वक्त में ये अकाउंट्स थे
Am I correct about that?
वो सच है
हाँ जी ठीक है
यस यार
So you were the one that contributed the funds to these accounts for them, correct?
आप जो थे जैसे आपने पैसे जो आपकी तरफ से आई थी इस अकाउंट में डालने के लिए शुरू से
मेरी तरफ से इस अकाउंट में पैसे नहीं हैं ये सारे बच्चों के हैं
they were not her money. It was not her money, it was her children's money.
Explain that to me.
वो ये समझा रहे जज साहब को पूछे ये समझाए
They weren't working as minors, right?
काम तो नहीं कर रहे थे माइनर्स की
अच्छा बात पूरी ये कि जब बच्चे माइनर्स थे उनके अकाउंट के मैंने पेपर्स साथ में भिजवाए हैं कि जब जब अकाउंट
slow. Thank you. You gotta slow down. The interpreter needs to be able to interpret this. Tell her that.
आपने थोड़ा एक ग्रुप में किसी से बात करनी है फिर मैंने इसको जज साहब को समझाना पड़ता है ना
ठीक है
तो
फर्स्ट चीज
जज पूछेगा तो बच्चे तो काम तो नहीं कर रहे थे माइनर्स पे
माइनर्स जब थे तब मैंने उनके साथ जॉइंट अकाउंट खुलवाया था
When they were minors, that's when she opened up the joint accounts.
Who contributed the funds?
पैसे किसने दी थी खोलने के लिए
पैसे उन्होंने अपने बाप से लिए थोड़े से खोलने के लिए उसके बाद बच्चों के कॉलेज से फंड्स आते रहे अकाउंट में मेरा कोई पार्ट नहीं है उसमें
Stop her. She can't go on for 2 sentences.
Yeah, आप ज्यादा लंबी बात ना करें बस जो छोटे जवाब देने
ठीक है
तो आप कह रहे थे she saying that the initial funds came from the father अब बाप की तरफ से पैसे आए थे उसके बाद कैसे
उसके बाद बच्चों को कॉलेज से फंड्स मिलते रहे अकाउंट में
some college funds that the children received.
Wait a minute.
So
Wait a minute.
Initial came from the father and then
Where's the father?
बाप कहाँ है
बाप अब जॉब पे है अब घर पे नहीं है
He's at work, not at home.
Do you work?
आप काम करती है
नहीं मैं काम नहीं करती हाउस वाइफ हूँ
No, she doesn't. She's a housewife.
Did you ever work?
आपने कभी काम किया है
नहीं कभी काम नहीं किया
No, she's never worked.
Now what do you have to say, counsel?
आप वो कह रहे हो काउंसिल से पूछ रहे आप बात करने का
I mean, look. You have the burden of proving, or at least the court's inquiry here is, go ahead, I'm sorry.
वो वकील को कह रहे तो उसकी जिम्मेदारी है सबूत निकालने की जो कोर्ट के सामने
The court's inquiry is as to who made the contributions. You agree with that, right?
वो जज कह रहे जो उसकी जिम्मेदारी है पूछने के लिए तो इनिशियल जो फंड्स ने किसने दी थी वो उसकी जो है जिम्मेदारी बताने का
You agree with that, right, Mr. Kuipers?
Yes.
वो पूछ रहे तो आप ये बात अग्री करते वो बोला हाँ
So if the father contributed the funds
जो बाप ने पैसे दी थी
to the children,
बच्चे को
and simply listed Ms. Burke
And सिर्फ आपका नाम पे डाला था फिर
as a co-owner of the account,
as a जो जिम्मेदारी की co-owner के लिए account की,
ठीक है
how is it that I can find that the garnishment is not exempt? In other words, wait, go ahead and tell her that.
तो वो जज उसको सवाल पूछे तो फिर वो क्यों नहीं ले सकते उसकी तरफ से? तो garnishment जो है ना वो exempt है.
इसलिए कि
No, I'm asking him.
वो आपसे नहीं पूछ रहे, वो वकील से पूछ रहे हैं.
I'm asking you, counsel.
Because per the statute cited,
वो जो statute जो अभी तो पढ़ा था,
a statutory joint account
ये joint account तो statutory joint account जो है,
shall be subject to the rights of creditors
वो एक जो हक होती है जो creditor करने जो होती है ज्यादा creditors के लिए,
to the extent of ownership.
जो उसकी जिम्मेदारी जो होती है owner की account की.
But you just agreed with me. Wait.
But
go ahead
she's
and tell her.
list-
Wait.
इसके जज ने उसकी दोबारा फिर वकील से बताया था, तो आप उसके लिए agree की थी.
She's listed as a co-owner on the account.
फिर co-owner के नाम पे account पे आपको list कर दिया है.
And therefore has right and full access to all the funds in the account.
और आप पे जी हक है जो जितना पैसे account की आपकी हक है उसके लिए access करने के लिए जितना पैसे है उस account में.
But as always, I defer to the court's discretion.
I think you're wrong.
वो कहता है वो फिर मैं कोर्ट के सामने में पेश करता हूँ.
I think you're wrong, and I'll.
Oh no, did it freeze? It froze.
Not you, Matt.
Huh?
Not
Not me?
you.
Okay.
No.
Still good for me too, interestingly enough.
I don't think that's ever happened before.
It's definitely the court.
Sorry for taking up all the time.
Slow down, man.
It's you.
Well, Your Honor, I'd like to call the representative investigating approach. Substation for the record.
You're gonna plead impeding?
Yes, Your Honor, the original charge is dismissed.
Jeez. All right, 10 years later, he shows up. To the charge of impeding traffic, responsible or not responsible? Plea is accepted, 220 is your total, the suspend's dismissed. You have a bond, it looks like a 134, you're gonna have to go down and pay the other 86.
Getting up to the end of the day tomorrow on this page.
Pay 134 now, that's the bond, pay the rest by September 4th. We close the doors, so you should be here by 4 o'clock, okay? Good luck, wish you well, thank you, Destiny Danier Henry. 25W837840. Can you finish up whatever you have, counsel, and bring it back in here and we'll get.
Yes. Word of honor, Your Honor.
Good morning, Your Honor. Mr. Sean Perry, I'm CSO.
Ma'am, your name? Wait a minute. All right, so you're very soft spoken. That's okay. But you got to keep your voice up for me, all right? So she's going to plead the destruction of property under HIDA.
That's correct, Your Honor. She's 22.
And is that what you want to do? If you do that, the possible penalties here are up to 500 fines, 90 days jail costs, or all those. I'll defer the proceeding taken under the Homes Youthful Training Act. We'll set it for sentence. If you're compliant at the end of the specified period of time, which they've agreed upon is 12 months, the case will be dismissed on motion of the prosecutor. Do you understand that? You got to keep your voice up. And you understand all your rights? Did you sign an advice of rights form today? She did not, did she?
No, I believe she might have signed one of the original right now.
That's not good enough. And take your time, sign this advice of rights for me, please. Make sure you read it and understand it. Go off the record. In fact, why don't you have a seat there? I'm going to go on to Weddington, Pamela Joyce Weddington, 25W839-467A and B. Your name, ma'am?
Pamela Weddington.
Shemke?
Good morning, Your Honor. Mr. Shemke, bearing with my client's statements on my left as to the arraignment away from reading my client's statement.
All right, ma'am, I'm gonna give you a personal bond, enter a not guilty plea, $500 personal bond. You cannot leave the state without consent or violate a law. You must appear in court as directed. When are we gonna set this for, Lisa? September 17th?
Yes,
Your Honor,
9:45.
I guess potentially, she's working with another attorney to get,
That's fine, but don't ask me to adjourn it again. I'll go to October 1. I'll go to October 1 at 9:45, okay? October 1 at 9:45. I mean, I might consider another couple weeks, but
I understand that.
okay. So I'll give you that. You're gonna go down the hall, you're gonna get your court date, your written paper notice. And if you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay?
Yeah.
Thank you. I wish you well. Do you have any questions?
No, sir.
Good luck. People against
Thank you.
Destiny Daniel Henry. 25W837 840.
Good morning, Your Honor. Mr. Shemke again. You have my client.
Ma'am, your name again? Do you understand everything I've said so far? You understand, nice and loud.
Yeah.
You understand the possible penalties? You understand you pleading guilty, you're giving up all the rights on the advice of rights. Have you now signed that document? Did you read it and understand it? All right. Do you have any questions before I ask you how you plead? To the charge destruction of property, how do you plead? Were you on Reek at 26530 Reek Road, apartment 263 in Woodhaven, June 24, 25?
Yes.
What did you do that makes you guilty of destruction of property?
I asked for this car in the machine.
All right, and you intended to kick it, correct?
Yeah.
Are you on probation or parole?
She had, Your Honor, I spoke with Ms. Tessino regarding it. She's already been violated. So there's, Ms. Tessino indicated that she had to do some work program days. She's already been in compliance with that. And before we even continued with this, I brought that to the attention of the prosecutor. And she's in a unique position to be able to walk away with this with some anger management classes, a no contact provision, and potentially legal criminal history.
So was she violating on the violation of law?
She was violated on the no contact provision, and then I told Ms. Tessino what we were doing today. She already indicated what her intention would be to discuss the matter with Judge Hessen, but she'd anticipate that the probation would run concurrent.
Okay, but you do understand Judge Hessen's going to make up her own mind, right, ma'am? That you might have your probation revoked. I'm just saying, as a result of this plea and conviction, and you could be incarcerated on that charge as a result of this plea and conviction. You understand that? You still wish to plead guilty? I'll take your plea. I find it to be an accurate plea, made voluntarily and understandingly. Was there any alcohol involved?
No.
PSI sentence date will notify the victim on this one. And you're going to go over across the hall. You're going to be interviewed, and then you'll come back for sentence. When do you want to do this one, Lisa?
September 17th at 8:30.
September 17th at 8:30, okay? September 17th at 8:30. All right? You understand everything? Okay, good luck. Thank you. We'll see you back here then. Do we have anything else here right now?
No, sure.
How's everything?
Keeping busy, Judge. Started back up at the Fire Academy. So I have that tonight. I did Fire Academy 1 and my husband, so I'll do the Fire Academy 2. So
Nice.
December.
Good.
It's funny, so I was the captain. So it's paramilitary. So there's 3 platoons, 3 lieutenants, 1 captain. So I was captain last semester, and I wasn't even going to be captain. I wasn't going to ask for it. But the chief came and goes, "Why aren't you applying for this position?" I said, "Well, you indicated that there's a shortage of firemen, and there's actually chiefs who come to the academy to look for firemen. And you know that I'm doing this as a volunteer." He goes, "I don't care about that. I want to be captain." So I did it last semester. And then this semester we come and you have to apply for positions. Now I've got acquainted with the job. I wouldn't be anything less. It's like, I'm not doing a demotion. But the chief, he goes, "Well, just so you know, sometimes we like to spread it around, so no promises." So first day of class was Wednesday, and there were some administrative things that needed to be done. So I already got ahead of that. I didn't charge for everyone the whole summer. Like it's a good group of people. And I go back and I talk to the chief. He goes, "Well, it looks like you're going to be captain again. You guys already doing stuff?" He goes, "No, actually, no one else wanted that position. Like you were," which made me feel pretty good that, my entire team, they wanted to keep it the way.
Nice.
So it's just, it's fire.
Nice.
Something to do.
Good. Good. Good for you. Kenyatta Davis.
Yes, sir.
Kenyatta, and I need all the sentencings. Kuru Davis II, 25W8378846, 25W8388014, 25W8378845, 25W8383352, 25W8383232, 25W837440.
Morning, Your Honor. Mike Hill Crawford, representing defendant, Porter Quarters 3 cases that are yours and 3 for Judge Heston. But there is a universal deal that's been presented to the court that will address all the cities.
You're in treatment now?
Yes, sir. Yes, sir. You sent me the treatment back in August, informing about the league.
All right, so I'm going to take a plea on retail fraud. This is on. So I can't read this. Which one am I taking?
Well, it's going to plead guilty to all 3 of the cases before you, which are the top 3. The others will be dismissed. I can write down Heston.
No, I can take that. Okay. I see. He filled out different stip forms, did he? What is going on? I don't even see the stip form. I see one stip form. It says he's going to plead guilty to retail fraud on the April 4th one. I don't see anything.
Second one on the dismissals.
Oh, I see a second one on the dismissals, but what about the other 2? 25W8388014. Wait a minute. Target February 8th. Can't even read this. Oh, I see. He wrote it up the side. So he's pleading, the defendant's pleading guilty on all the cases in front of me. They are from July 9 of 25, on April 4 of 25, and on July 8 of 25. True?
He's pleading no contest, yes.
Why no contest?
Lack of recollection. He's had a bad drug problem there at the time. He does not remember what was going on.
You don't remember any of these? Did you guys bring me these? And
No, Judge.
hang on. You guys will help me if you pull out the police reports for me. I have no clue what file or files these are in. I'm going to ask you to pull all those police reports. And I don't know if they're in there, not in there, and then I'll go ahead and take the plea. Go off the record. Derek Arthur Shulman, 25M577571A. Then it failed to appear. Show cause. This is on Judge Heston's. Or I guess it's my case now. Warrant to issue. 3,010%. Yeah, these are mine. They were transferred over with the state doc. Default judgments entered yesterday for failure to appear. People against Laskowski. Eugene Francis Laskowski, 25W838939, A and B. An issue a show cause on the B file and on the A file. Default judgments entered for failure to appear. Blair. Lisa Marie Blair, 25W838228. Then failed to appear. Issue a show cause. Jason Andrew Bartel, 25W839334 A and B. Then failed to appear. Issue show cause. Hooks. Keyshawn Deswan Hooks, 25W839402 A and B. Then failed to appear. Issue a show cause on the B file. Default judgment on the A file. Watt, Daniel, Mart, Amos, Watson, 25W838411. Then failed to appear. Issue a show cause on that. Zah, Nadal, El Halawala, 25W39293. A, B, and C. I'm going to issue a warrant on the failure to appear in the misdemeanor file, which is file C. Default judgments were already entered on the A's and B's. El Jaha. All right, all these are show causes, and I'm going to run through these real quick. Not here. People against Defala, Muhafa, El Jahaf, 25T645-379B. Warrant issue 282 cash or surety. On 379A, that's 25T 645-379A, 213 cash or surety. Tyrone Edwards Armstrong Jr., 25W838-625, 213 cash or surety. Anthony Antonio Jerome Arnold II, 25W838-624, 282 cash or surety. Jordan K. Bland, 25U567364, warrant issued 279 cash or surety. Andrew Michael Bouchard, 25W838-476, 213 cash or surety. Christopher Ian Burr, 25T645-432, 213 cash or surety. Chapman, Andrew Chapman, 25W838-643, 237 cash or surety. Jacob Robert Dillon, 25T645-403, 282 cash or surety. Rachel Catherine Eves, 25B148450. Mr. Crawford, don't go too far. 237 cash or surety. Rise Ronald Graham, 25W838-617, 213 cash and surety. Shaquila Charmaine King, 25W838-529, 237 cash or surety. Christopher Michael Cleast, 25B148619, 285 cash or surety. Regina Elizabeth Miller, 25W838-113, 195 cash or surety. Kalaya Danielle Price, 25G306456. 13 cash or surety. Larry Michael Provost, 25F243891, 213 cash or surety. Gagandeep Kaur Seacon, 25F243889, 237 cash or surety. Damon Lenice Marie Smith, 25W838-635A and B. Those will be warrants and bonds, 135 and 282 cash or surety respectively. Aljani Latman Williams, 25B148618, A and B, 213 and 282 cash or surety respectively. April Lachey Chavis, 25B147401A, Bennett failed to appear on September 3. Warrant issue 405 cash or surety. Carrie Lynn Andrew. I need to talk to the prosecutor about this one. 25W837427. Defendant failed to appear. I don't know what this person's doing here, counsel. Your appearance?
Michael Crawford, person of the defendant.
Well, first of all, you guys agreed to take it under 771.1 for 18 months. So,
I'm sorry, Your Honor. Oh, we defendant are we on the
this is Carrie Lynn Andrew.
She didn't show us. Sucks. Down.
So your appearance?
Good morning again, Your Honor. William Merrick on behalf of the city of Woodhaven.
Arrested defendant was in Dearborn for possession of controlled substance and possession of drug paraphernalia. Arrested in Wyandotte for loitering. That's from November of 24. Arrested in Wyandotte for loitering where drugs are present. In possession of drug paraphernalia. There's another warrant out for possession of narcotic equipment and possession of marijuana. And then has a warrant out of Osceola County for neglect of child and child support. I can't take a plea under 771 for 18 months. So you guys sent this in. Listen, this isn't today. You sent it in on April 30. And the defendant didn't show up. And I noticed it was for 18 months on the STIP form. I'm not saying you did it. I think it was somebody else. But I can't take a 771 plea for 18 months. Second, I need to know what these others are about. If this is a fourth and just there's been no convictions because they didn't show up before, I'm not taking this under 771.1. with all those prior drug convictions, this being a drug period.
Sentence.
Yes.
Oh,
That being said, defendant just forfeited 7,500, 10% bond by not appearing. So what happens then? Well, it's just going to be doubled, 15,000, 10% on Carrie Lynn Andrew. I'm going to need you in here on the one case here very shortly, Jeremy Shaw.
yes, sir.
So I'll call you when it's necessary. Thank you. Anthony William Rose, 25W838586.
This courtroom exchange quickly becomes tense when a woman asks the judge to step aside from her case, claiming there is some kind of bias or conflict. But the judge is clearly not convinced. As the woman tries to explain her concerns, she repeatedly interrupts, and the judge has to remind her to stop talking over the court. The judge explains that there must be an actual legal basis to support a request for recusal, and says there is nothing presented that shows she is biased, either for or against the defendant. Things become even more heated when the woman continues making accusations. The judge firmly rejects them, calling the allegations so unreasonable that they are laughable, and makes it clear that she is not going to continue arguing about the issue. Instead, the judge orders her to move away from the podium, attend the required examination, and get her next hearing date. The judge says the remaining issues can be addressed properly when the case returns to court. But the woman still has more questions and asks about getting a record of an earlier court hearing. The judge responds that she doesn't even remember which hearing the woman is referring to, but explains that if she wants a transcript, she can formally request it and pay to have it prepared. Once again, the judge stresses that she is not treating the woman unfairly, and that this is simply how she handles cases in her courtroom. The tension continues as the judge repeatedly tells the woman to back away from the podium. When she fails to immediately follow the instruction, the judge warns her not to force the court to take further action. It is a clear reminder that courtroom arguments have limits, and once a judge has ruled, continuing to interrupt or challenge the court in the same way can quickly make the situation worse. What do you think? Was the judge right to shut down the